So what do you think the best approach is for being successful in mediation?
One is keep an open mind, and the second is to consider what we call the BATNA, or the best alternative to a negotiated agreement. You have to consider you're going to negotiate some sort of settlement at some point. So consider what your alternatives are. One of those alternatives is litigation, and you can consider the possibility that you may not win, you may lose everything. That's not a very good alternative.
Doesn't feel like the best alternative.
Right. But you need to consider it. You need to think about what if you have a negotiated agreement sitting in front of you, an offer from the other side, and to think about it. There's an exercise we do in class. I won't go through the details, but the students have to look at, either take a little bit or nothing. And sometimes getting a little bit of a solution is a way to end it. You need to consider that. And I think that the parties need to realize that if they're going to settle anyway, the sooner they get to a settlement that is fair and that they can live with, the less money they're going to spend on the journey to get there.
Yeah. We actually have quite a bit of time left, Jeff.
Okay.
So maybe you can tell us some examples, some stories about maybe some of these cases that you've dealt with and how these approaches have worked.
Oh, there's so many, but let me give you a couple of good examples of situations that have come up. And this touches on your field, by the way. One of the things that there's a case that involved two attorneys who were getting divorced, and of course they had each hired attorneys of their own. One of the things that came up in the process of trying to settle the case and try to work it out was that the one attorney was telling their client that they should take the settlement that was being offered. It was a good deal, and just take it and run with it and leave. And so the woman in that case thought this was a good deal. She was going to leave, nothing to worry about. And so she took the deal, they signed all the paperwork, and they went ahead and that settled the case. She found out later two things. One is her attorney and her husband's attorney were in the process of forming their own law firm.
Whoops. A conflict of interest.
So
there.
we had a conflict of interest. Very clearly a conflict of interest problem there. But the other one was probably even more drastic, and that was that her attorney had not done the research into an area of veterans' benefits. The husband had some rights and some benefits which she was entitled to under the community property laws. So if she had kept some part of that, she could have been eligible for lifelong benefits and other elements to it. And she discovered after she waived all of her rights to it that she was permanently barred from going back and taking any of those benefits. Moreover, and this is where your area comes in, they had calculated that she would have enough money at the end of the negotiations from the proceeds from some other aspect of the transaction to actually pay for and buy the house that they had to divide. Didn't take into account the tax considerations. And this has become an issue more and more, and attorneys that practice civil litigation often are not tax attorneys.
Right.
And I always encourage them, go see your CPA. Make sure your CPA reviews the process before you sign on it. And this is a problem where, again, why is litigation more expensive? Because there are complicating factors such as the effects of tax law on settlement amounts. Income is taxable as a general rule. So if it's a personal injury case, you have exemptions for things like personal physical injuries, but punitive damages are taxable. Any awards are done, and if you get other proceeds, they're all going to come with a tax hit. We remember the famous example of Oprah giving free cars to everybody, and they ended up getting a tax hit.
Yeah, right.
So that's one factor that is become a little more revealing for negotiators. The other one is, and again, the burden falls on the parties to be very aware of all of the consequences that come out, and so they have to take these into account to look at what works best for them, what is their timeline. If you only have a little bit at stake, I always ask my clients, what's at stake? If it's only a few $1,000s, they have to consider that it could be multitudes of 3 or 4 times that to see a case go through litigation. So I ask him, are you seeking revenge or are you seeking justice? You know, make a business decision. And if you make it a business decision, you're probably going to settle early on and move on and not waste a lot of time. What's the best use of your next 10 minutes of time? Is it to go fight an old battle or to move forward in your business and use that time to keep building your business and get away from the bad supplier that made a mistake? So that's a big difference in the way I like to approach it in terms of negotiating a solution to a problem. Now, there's a couple other things that happen in the court. If you find yourself being sued and you say, well, Mr. Hare advised us to rush in and settle, sometimes you don't want to do it too early. There's a timing issue. Sometimes parties need a little bit of time to think it over, and they need some time to kind of sense where the other party stands. So you don't want to rush in and try to settle the minute you get sued, but give it a little bit of time, but don't wait too long.
You know, I got involved in a mediation that actually related to an estate. I have to be careful on, you know, getting out too much of the details, but what I can tell you is that it was a, you know, sort of a sensitive situation, again, related to a trust or estate, where father had not really settled mother's estate, and then he had remarried. And so the kids were saying, you know, we want our inheritance, we want to get this thing taken care of, and then unfortunately Dad had passed away, so you know, the surviving spouse had to take care of it. And so we're looking at this, you know, trying to figure out how to pick up the pieces and deal with this, and what was the most effective way. And basically, you know, I think everybody knew, at least all the attorneys, and I knew that this was going to have to be a mediation. There really wasn't any other way. Anyway, so one of the sets of attorneys had done a lot of preparation, had lots of PowerPoints and other things, and I think with the anticipation that what we were going to be doing is sitting down all together at the table to hammer this thing out. But the attorney that they had hired to be the mediator decided on a different approach, which was closer to a car dealership closing situation.
Right.
So in other words, what he did was he isolated each of the groups, and then basically would hammer out a proposal with each one, and then sort of go back and forth until somehow they came to a middle ground, with the understanding that neither side was going to be happy with whatever he came up with. And anyway, so I guess part of what I wanted to point out with it, though, is that there isn't just one way for doing this stuff.
Right. Well, actually, in mediation, the parties have the ability to solve their own dispute. Again, going back to the contrast, arbitration is where the parties submit their argument to a neutral third party. The mediator is also neutral, but he or she will help facilitate a solution, and the parties can work something out. One of the beauties of the mediation process is that the parties can sometimes fashion a result or an outcome that is better than anything that the court itself can fashion. And the mediator, if they're knowledgeable in the area of the law that's involved and is able to work with the parties, sometimes could get the parties to see beyond the dispute itself and settle even other issues that came in. I had a case come to me once where the parties brought a little tiny dispute into the arena I was working in, but they had 4 other lawsuits going.
Oh my gosh.
And that's right. And they had been litigating for 3 to 4 years, and I could tell right away they were exhausted. They were just beat up with attorney's fees and the time, and you could tell that they had just really wanted to move on. So I said, would you like to resolve all of those issues at this point? You have total control of your future, your destiny. You can bring all of the cases to an end, and would you like to do that? And they both nodded, yes, they would. In that case, yes, I did keep them in the same room. Sometimes I do split the parties up if it's more efficient that way. And we went ahead. It took 3 days, but we went through and got resolution on every single point in all 4 cases, one of which was pending before the California Supreme Court.
Oh my gosh.
And I remember getting a phone call from a local judge at 5 o'clock late Friday afternoon, and he goes, "How did you do that?" And I said, "I didn't do anything except help the parties get what they were trying to do." But the parties have that ability to solve these matters. And I think that's the key here, is you finding that one thing that gets them to start thinking about dispute resolution rather than furthering the dispute is what we look for.
Yeah, because these things, litigation can just drag on and on and on, and as it drags on, like you said, the meters are running around with all of these parties, and sometimes you even have other professionals that are involved, like CPAs, that may be contributing, and so when you add it all up, it's just overwhelming. And so again, that's why, especially when you're dealing with something that's fairly modest as far as the issues that are concerned, it just doesn't make sense to, it's just going to all get consumed by the lawyers anyway. They're not going to, the other people aren't going to get anything.
Well, don't kid yourself. The lawyers often go this time without getting paid. The attorneys, the fact that there's huge amounts of attorney's fees is usually a factor that kicks in late in the process and prevents the parties from settling. They may have had originally a $10,000 or $15,000 dispute over a business transaction, or failure to pay that last lease payment, or the dispute over a security deposit. Now it's 3 years later, and the attorney's fees are upwards of $100,000 to $150,000, and there's expert witness fees, filing fees, all of this stuff is there. And that's what's keeping the parties from coming to a resolution. They've long ago solved the split on what the original obligation was. Now the issue, who's going to pay the fees, becomes the overarching one. But remember, at that point in time, the attorneys probably haven't even gotten paid. So sometimes the attorneys themselves have to meet and negotiate with their clients about how much they're willing to write down in order for the dispute to go forward. And I've seen cases like that more times than I care to count.
No,
that's right.
You don't want that.
And last time I saw, attorney's fees are not always deductible.
Well, that's true, especially with this thing called the alternative minimum tax. But that could be a whole other program, so we're not going to talk about that today. Okay, well, we just have a couple minutes left. Maybe you can throw out maybe some final thoughts related to this area.
Sure. I think everybody who's facing a challenging dispute, I think the first thing they need to do is stop and take a look around them and realize, how did they get there? If a dispute jumps up in front of them, or they get an angry customer or client, or somebody's really upset, the first thing they say is, how did this happen, and how did you get there? If you know how you got there, it's a good clue that how to get out of it. Second of all, consult with a professional. You can find out that there may be some serious problems that you could face if you don't handle it right. The worst thing you can do is do nothing. I've had parties that say, well, I'll just ignore it and it'll go away. Next thing you know, you've got a judgment against you. It's on your record. You can lose your professional licenses. You can do all sorts of things. They can attach your credit card accounts. Don't ignore the case. Take a look at it. Consult with a professional. But as soon as you can, start to look at, how could I settle? What would be a reasonable settlement posture to take at different stages along the line? And the sooner you get your head into that mode, and the sooner you can accomplish that, the sooner you're probably going to be able to wrap up the dispute and move on with your business, and move on with your life.
Great. Jeff, I want to thank you so much for coming and being my guest and sharing this important information with our viewers. So folks, if you get involved with a lawsuit, well, especially these days, as Jeff has said, you may not have a choice. You really do need to look at, how can you settle, how can you resolve these matters as quickly as possible without going to court. We've tried to give you a little information along that line today, and we hope that you'll find it helpful. And we'll hope that we'll see you next time on Financial Insider Weekly.